My immediate aim is to show that this new imperialism is the natural result of historical circumstances. It is well, however, to bear in mind several considerations which Englishmen of today are apt to overlook. The friendly imperialism which finds expression in the imperial conferences is itself the admirable fruit of the old policy of laissez-faire. The system of leaving the self-governing colonies alone first appeased discontent, and next allowed the growth of friendliness which has made it possible for the English inhabitants, and even in some cases the foreign inhabitants of the dominions, to recognise the benefits which the Empire confers upon the dominions, and for Englishmen at home to see that the dominions may contribute to the safety of England and to the prosperity of the whole Empire. But we must at the same time recognise that the policy of friendly indifference to secession from the Empire, which nominally at any rate was favoured by many English statesmen during the 19th century, has come to an end. The war in South Africa was in reality a war waged not only by England but also by the Dominions to prevent secession. The concession further to the South African Union of the full rights of a Dominion is no more inconsistent with resistance to secession than was the restoration to the Southern States of the American Commonwealth of their full right to existence as States of the United States. It must lastly be noted that while the inhabitants of England and of the Dominions express at each conference their honest pleasure in imperial unity, the growth of imperialism already causes to many patriotic men one disappointment. Events suggest that it may turn out difficult or even impossible to establish throughout the Empire that equal citizenship of all British subjects which exists in the United Kingdom, and which Englishmen in the middle of the 19th century hoped to see established throughout the length and breadth of the Empire. The rule of law. The rule of law, as described in the treaties, remains to this day a distinctive characteristic of the English constitution. In England, no man can be made to suffer punishment or to pay damages for any conduct not definitely forbidden by law. Every man's legal rights or liabilities are almost invariably determined by the ordinary courts of the realm, and each man's individual rights are far less the result of our constitution than the basis on which that constitution is founded. The principles laid down in this treatise with regard to the rule of law and to the nature of droit administratif need little change. My object in this introduction is first to note a single decline among modern Englishmen in their respect or reverence for the rule of law, and secondly, to call attention to certain changes in the droit administratif of France. Decline in reverence for rule of law. The ancient veneration for the rule of law has in England suffered during the last 30 years a marked decline. The truth of this assertion is proved by actual legislation, by the existence among some classes of a certain distrust both of the law and of the judges, and by a marked tendency towards the use of lawless methods for the attainment of social or political ends. Legislation. Recent acts have given judicial or quasi-judicial authority to officials who stand more or less in connection with, and therefore may be influenced by, the government of the day, and hence have in some cases excluded, and in others indirectly diminished, the authority of the law courts. This tendency to diminish the sphere of the rule of law is shown, for instance, in the judicial powers conferred upon the Education Commissioners by the Education Act 1902, on various officials by the National Insurance Acts 1911 and 1913, and on the Commissioners of Inland Revenue and other officials by the Finance Act 1910. It is also shown by the Parliament Act 1911, Section 3, which enacts that any certificate of the Speaker of the House of Commons given under this Act shall be conclusive for all purposes and shall not be questioned in any court of law. This enactment, if strictly construed, would protect any speaker who, either from partisanship or to promote some personal interest of his own, signed a certificate which was notoriously false from being liable to punishment by any court of law whatever. No doubt the House of Commons has been historically jealous of any judicial interference with persons acting under the authority of the House, and has on more than one occasion claimed in a sense to be above the law of the land. All that can be said is that such claims have rarely been of advantage or credit to the House, and that the present time is hardly the proper season for the curtailment by the House of legitimate judicial power. It must, however, in fairness be noted that the invasion of the rule of law by imposing judicial functions upon officials is due, in part, to the whole current of legislative opinion in favour of extending the sphere of the state's authority. The inevitable result of thus immensely increasing the duties of the government is that state officials must more and more undertake to manage a mass of public business, e.g., to give one example only, the public education of the majority of the citizens. But courts are from the nature of things unsuited for the transaction of business. The primary duty of a judge is to act in accordance with the strict rules of law. He must shun, above all things, any injustice to individuals. The well-worn and often absurdly misapplied adage that it is better that 10 criminals should escape conviction than that one innocent man should without cause be found guilty of crime does after all remind us that the first duty of a judge is not to punish crime but to punish it without doing injustice. A man of business, whether employed by a private firm or working in a public office, must make it his main object to see that the business in which he is concerned is efficiently carried out. He could not do this if tied down by the rules which rightly check the action of a judge. The official must act on evidence which, though strong, may not be at all conclusive. The official must often act with severity towards subordinates whose stupidity, and not their voluntary wrongdoing, gives cause for dismissal. A judge, on the other hand, is far more concerned with seeing that the law is strictly carried out than in showing consideration to individuals. That hard cases make bad law is proverbial. The transaction of business, in short, is a very different thing from the giving of judgments. The more multifarious, therefore, become the affairs handed over to the management of civil servants, the greater will be always the temptation, and often the necessity, extending to the discretionary powers given to officials, and thus preventing law courts from intervening in matters not suited for legal decision. Distrust of judges and of courts. If the House of Commons deliberately excludes the intervention of any law court in matters which the House may deem, with very dubious truth, to concern the House alone, we can scarcely wonder that artisans should have no love for judicial decisions. In plain truth, while every man of at all respectable instincts desires what he considers justice for himself and for the class to which he belongs, almost all men desire something more than, and different from, justice for themselves and against their neighbours. This is inevitably the case with persons such as the members of trade unions, who are trying, with a good deal of success, to enforce trade rules which often arouse the censure of the public and sometimes come into absolute conflict with the law of the land. The blackleg may be, and one may suspect often is, a mean fellow who, to put money into his own pocket, breaks rules which his fellow workers hold to be just and beneficial to the trade generally. He, for example, has no objection, if properly paid for it, to work with men who are not members of any union. The blackleg, however, all but invariably keeps within the law of the land, and proposes to do nothing which violates any principle established by common law or any enactment to be found in the statute book. The trade unionists whom he offends know perfectly well that the blackleg is in the eye of the law no wrongdoer. They therefore feel that the courts are his protectors, and that, somehow or other, trade unions must be protected against the intervention of judges. Hence the invention of that self-contradictory idea of peaceful picketing, which is no more capable of real existence than would be peaceful war or unoppressive oppression. Hence, too, that triumph of legalised wrongdoing sanctioned by the 4th section of the Trade Disputes Act 1906. It is, however, by no means to be supposed that artisans are the only class accustomed to decry a judge or the legislature when the one gives a judgment or the other passes a law opposed to the moral convictions of a particular part of the community. Lawlessness. Till a time well within the memory of persons now living, it would have been very difficult to find any body of men or women who did not admit that, broadly speaking, a breach of the law of the land was also an act of immorality. No doubt at all times there have existed, as at the present day, a large number of habitual lawbreakers, but though a cheat, a pickpocket, or a burglar does constantly break the law, there is no reason to surmise that cheats, pickpockets, or burglars maintain the doctrine that law-breaking is itself a praiseworthy or a moral act. Within the last 30 years, however, there has grown up in England, and indeed in many other civilized countries, a new doctrine as to lawlessness. This novel phenomenon, which perplexes moralists and statesmen, is that large classes of otherwise respectable persons now hold the belief and act on the conviction that it is not only allowable but even highly praiseworthy to break the law of the land, if the lawbreaker is pursuing some end which to him or to her seems to be just and desirable. This view is not confined to any one class. Many of the English clergy, a class of men well entitled to respect, have themselves shown no great hesitation in thwarting and breaking laws which they held to be opposed to the law of the Church. Passive resisters do not scruple to resist taxes imposed for some object which they condemn. Conscientious objectors are doing a good deal to render ineffective the vaccination laws. The militant suffragettes glorify lawlessness. The nobleness of their aim justifies in their eyes the hopeless and perverse illegality of the means by which they hope to obtain votes for women. Whence arises this zeal for lawlessness? The following reflections afford an answer, though only a partial answer, to this perplexing inquiry. In England, democratic government has already given votes, if not precisely supreme power, to citizens who, partly because of the fairness and the regularity with which the law has been enforced for generations in Great Britain, hardly perceive the risk and ruin involved in a departure from the rule of law. Democratic sentiment, further, if not democratic principle, demands that law should on the whole correspond with public opinion. But when a large body of citizens not only are opposed to some law but question the moral right of the state to impose or maintain a given law, our honest democrat feels deeply perplexed how to act. He does not know, in effect, how to deal with lawlessness, which is based upon a fundamental difference of public opinion. For such difference makes it impossible that on a given topic the law should be, in reality, in accordance with public opinion. Thus many Englishmen have long felt a moral difficulty in resisting the claim of a nationality to become an independent nation, even though the concession of such a demand may threaten the ruin of a powerful state and be opposed to the wishes of the majority of the citizens thereof. So the undoubted fact that a large number of English women desire parliamentary votes seems, in the eyes of many excellent persons, to give to English women a natural right to vote for members of Parliament. In each instance, and in many other cases which would occur to any intelligent reader, English Democrats entertain a considerable difficulty in opposing claims with which they might possibly, on grounds of expediency or of common sense, have no particular sympathy. The perplexity of such men arises from the idea that, at any rate under a democratic government, any law is unjust which is opposed to the real or deliberate conviction of a large number of citizens. But such a conviction is almost certain to beget, on the part of persons suffering under what they deem to be an unjust law, the belief, delusive though it often is, that any kind of injustice may under a democratic government be rightly opposed by the use of force. The time has come when the fact ought to be generally admitted that the amount of government, that is, of coercion, of individuals or classes by the state, which is necessary to the welfare or even to the existence of a civilized community, cannot permanently coexist with the effective belief that deference to public opinion is in all cases the sole or the necessary basis of a democracy. The justification of lawlessness is also, in England at any rate, suggested if not caused by the misdevelopment of party government. The rule of a party cannot be permanently identified with the authority of the nation or with the dictates of patriotism. This fact has in recent days become so patent that eminent thinkers are to be found who certainly use language which implies that the authority or the sovereignty of the nation, or even the conception of the national will, is a sort of political or metaphysical fiction which wise men will do well to discard. Happily, crises arise from time to time in the history of any great state when, because national existence or national independence is at stake, the mass of a whole people feel that the authority of the nation is the one patent and the one certain political fact. To these causes of lawlessness, honesty compels the addition of one cause which loyal citizens are most anxious not to bring into prominence. No sensible man can refuse to admit that crises occasionally, though very rarely, arise when armed rebellion against unjust and oppressive laws may be morally justifiable. This admission must certainly be made by any reasoner who sympathises with the principles inherited by modern liberals from the Whigs of 1688. But this concession is often misconstrued. It is taken sometimes to mean that no man ought to be blamed or punished for rebellion if only he believes that he suffers from injustice and is not pursuing any private interest of his own. Comparison between the present official law of England and the present droit administratif of France. The last 30 years, and especially the 14 years which have elapsed since the beginning of the 20th century, show a very noticeable, though comparatively slight, approximation towards one another of what may be called the official law of England and the droit administratif of France. The extension given in the England of today to the duties and to the authority of state officials, or the growth of our bureaucracy, to use the expression of an able writer, has, as one would naturally expect, produced in the law governing our bureaucrats some features which faintly recall some of the characteristics which mark the droit administratif of France. Our civil servants, indeed, are as yet not in any serious degree put beyond the control of the law courts, but in certain instances, and notably with regard to many questions arising under the National Insurance Act 1911, something very like judicial powers have been given to officials closely connected with the government, and it may not be an exaggeration to say that in some directions the law of England is being officialised, if the expression may be allowed, by statutes passed under the influence of socialistic ideas. It is even more certain that the droit administratif of France is year by year becoming more and more judicialised. The Conseil d'État, or as we might term it, the Council, is, as all readers of my 7th edition of this work will know, the great administrative court of France, and the whole relation between the judicial courts and the Council still depends, as it has depended now for many years, upon the constitution of the conflict court, which contains members drawn in equal number from the Council of State and from the Court of Cassation. It would be ideal to suppose that the decisions of the Council itself, when dealing with questions of administrative law, do not now very nearly approach to, if indeed they are not in strictness, judicial decisions. The Council, at any rate, when acting in a judicial character, cannot now be presided over by the Minister of Justice, who is a member of the Cabinet. Still, it would be a grave mistake if the recognition of the growth of official law in England and the gradual judicialisation of the Council as an administrative tribunal led any Englishman to suppose that there exists in England as yet any true administrative tribunals or any real administrative law. No doubt the utmost care has been taken in France to give high authority to the Council as an administrative tribunal and also to the conflict court. Still, the members of the Council do not hold their position by anything like as certain a tenure as do the judges of the High Court in England, or as do the judges, if we may use English expressions, of the French common law courts. A member of the Council is very rarely dismissed, but he is still dismissible. It must be noted, further, that the Minister of Justice is still the legal president of the conflict court, though he does not generally preside over it. When, however, the members of the conflict court are equally divided as to the decision of any case, the Minister of Justice does preside and give his casting vote. It is indeed said that such a case, which must almost necessarily be a difficult and probably an important one, is in truth again heard before the Minister of Justice and in effect is decided by him. A foreigner without practical acquaintance with the French legal system would be rash indeed were he to form or express an assured opinion as to the extent to which the decisions of the Council or the Conflict Court are practically independent of the wishes and the opinions of the Ministry of the day.